We've got three case numbers, Your Honors, 19 CF 3340, 20 CF 756, and 19 CF 3365. I know Mr. Saline represents him in one of those.
Mr. Saline.
Mr. Saline, can you join us?
Your Honor, can I speak for the record too?
Williams, finished knowledge.
Yes, sir.
So I think we're set to go to trial on 193365 next week. And I presume 2756 as well.
Yes, Judge.
I know that we had a couple motions that we dealt with last week.
I didn't rule on the motion to consolidate.
I don't
You
believe
did, Judge. You granted it last week. I don't know if there's been a written order, but you granted it in court. I actually had filed a amended information consolidating those two counts, but I left it on the printer this morning, so I will file that.
Okay.
My intention is in the 193365 case, he is currently charged with two counts. One is the felon in possession of a firearm. That would have to be bifurcated anyways. So I had not included that in the amended information, and I plan on moving forward with the attempted first degree murder with a firearm and the tampering of the witness at trial next week.
Okay.
And my recollection, Judge, was that you, at that hearing, I remember you saying that you were inclined to grant the joinder of them. I'm not sure. You may have said it.
But if I did and just out of an abundance of caution, I'll grant the motion.
And that was certainly, I anticipated you do that, and I've been acting accordingly. I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that, but considering the
Hey,
fact—
Your Honor, this man ain't even helped me in my
Marty,
defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
what I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365. The attempted murder case is a life sentence, in that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right, he's choosing not to do that. But I did want that on the record so that there was no confusion later on about whether or not I had informed him of the offers and how I advised him and that sort of thing. So,
Your Honor, my intention is to revoke those offers today, and I plan on moving forward next week. One thing that Mr. Williams mentioned, yesterday I filed the HBFO notice, which actually extends his exposure in the tampering case from 30 years to possible life in that case as well. Okay. So the maximum that Mr. Cromartie faces is 2 life sentences consecutive.
Okay.
I really wasn't aware of that. You hear what he said?
Yes, sir. But
so let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being him, being that he's representing me, we haven't even worked the defense in this case at all, period.
Okay.
And plus,
let's take one thing. You understand that you've been off for 25 years in prison.
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
I don't understand, because I'm innocent. I don't know. I don't know what's going
Listen,
on. I don't
listen,
know what they. I don't know what.
Listen, you've entered a not guilty plea. So there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum.
Minimum mandatory minus the time you served in jail. No, I just need to, you understand that's the plea offer from the state.
Hell no. I don't understand none of this. What he talking? And it's a conspiracy between these two. Right here?
Listen, Mr.
Man.
Cromartie, Mr. Cromartie, what do you?
Man, I don't understand, sir. And
I don't believe you, Mr. Cromartie, because you act like you do understand it. But what are you asking for right now? What are you asking for?
I'm asking for him to be removed off my
Raise
case.
your right hand to be sworn.
I do.
Wait till the oath is done, sir. Do it again, madam.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Mel Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamel Cromartie, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my Fourth and Fifth Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my Fifth Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr.
Just
Cromartie,
don't-
what are you asking me today? I'm gonna give you
No,
one.
I
chance.
don't need him on my case.
Okay, are you at, listen, what are you asking me to
Or
do?
this one right here. This both them two right there.
Okay,
I got some that's conspiracy on what they trying to do.
okay, what do you want me to do?
Continue my trial.
No,
Till I
sir,
get-
motion denied. What are you asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right now, you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself, or are you gonna hire another attorney?
I'd rather represent myself to get an attorney.
You already sworn in, so state your name again.
Jamel Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week, is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay, do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court, is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you're agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that, is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest, and that would settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
It's a
correct?
lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court. Is that correct?
I'm not gonna say I'm being truthful.
When you
I
said
don't understand.
you don't
You
understand.
got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't
understand.
understand because there's some shit.
So you
that's
don't
going on.
you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade,
And you read and write?
barely. I could barely spell.
Okay. And you understand if you represented yourself, you'd have to do everything a
I'm
lawyer
gonna
did.
do what I can that I've been trying to do.
Do you understand you'd have to do
I do
everything?
better than him.
Listen to me. If you want to represent yourself, you've got to answer these questions. If not, I can't allow you to represent yourself. So,
I ain't trying to make a fool of myself, but Yana, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're going to pick a jury Monday morning. I'm not continuing the case. And you're going to try the case next week if you represent yourself.
Okay.
And you read and write.
I'm gonna learn.
You don't have time to learn. So you can barely read and write. Is that correct? You don't understand about the plea offer. You understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm gonna find that you're not competent to represent yourself. Mr. Salim will stay on his case. Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury.
All right. I've got one, Your Honor. State of Florida versus Devontae McCoy.
Mr. McCoy?
That's Mr. McCoy.
Yes.
Your Honor, there are three case numbers. I represent Mr. McCoy in the two that are from 2020. That's 20 CF 3136 and 20 CF 4047. If you'll recall, Your Honor, Mr. McCoy represents himself in 23 CF 204.
Mr. McCoy, I've already found that you're competent to represent yourself in that case. Do you still wish to represent yourself in that case?
I do.
Mr. Williams?
Your Honor, we have a new state attorney assigned in the two cases I'm representing him in. And I believe the state probably needs a little time to get acquainted with the case. We've talked informally. It's my understanding he'd like to kick it to another pretrial.
Yes, sir.
Well, Mr. Clark, can I say something, sir?
Yeah, you can address, yes, sir, address your case also, the one you're representing yourself. Also.
Right. Yes, sir. On that case,
That's for the record, that's 23 CF 204.
Yes.
yeah, well, I got a couple motions I want to file on that one, but
Okay.
about that case, so can I ask why am I being held without bond?
Sir, Mr. McCoy, we've gone over that. I revoked your bond, I believe, in the K2 case numbers because of the arrest. So I think we've already adjudicated that and litigated that. I'm gonna litigate it, but that's why you're being held without bond.
I mean, is there a reason though, sir? Like,
Yes, sir,
reason we're being held without bond?
because you were out on bond and you picked up another charge.
But I'm innocent on that charge, Mr. Clark, and I got the evidence.
Absolutely, you're presumed innocent on all the charges. I assume you're not admitting that you're guilty on the two charges that you're out on bond on. You're presumed innocent on all three of the charges.
Can I ask that the state has filed a motion to hold me without bond, Mr. Clark?
No, sir, I believe the court, I believe, and I may be wrong, I may have done it on my own motion.
You had a hearing in February, I believe it was February 24th, and then you addressed it also at our last hearing on October the 17th.
There was an order of revocation of release, and that was done by the first appearance judge on January 18th. So that judge held a hearing and revoked your bond or issued basically a warrant and held you without bond. So that, and I upheld that.
Well, I understand, sir, but it's been since January. Is there a reason why you feel like I need to be held without bond?
Yes, sir, because you picked up another charge while you were out on bond.
Well, Mr. Clark, I'm just speaking real quick.
Go ahead, do it quick. I've already addressed that. I don't have to make it any plainer for you.
Have a little patience with me, sir. I understand that's judges. They should be patient with their client, with litigants.
Well, I'm as patient as you. I'm gonna be patient. I'm gonna treat you just like a lawyer, and I'm treating you just like a lawyer. And when a lawyer goes to repeating themselves or re-litigating something that's already been litigated, I give them very little short leash. And that's basically what I've done to you. I've addressed that so many times. I'm not prepared to address it again today. So if you want to talk about something else, let's move on. But I'm not going to reinstate your bond today. Okay?
Actually, why, Mr. Clark?
Yes, because you picked up another charge while you were out on bond.
Well,
That is just,
okay.
I know that you say you're innocent, and you've said you're innocent on.
Listen, I just want to say this one thing, Mr. Clark. One thing, but we can move on to the next thing.
Okay.
Okay. What makes me different from the person that you released last month?
I don't know.
I picked up a driving on suspended license charge.
I got no idea.
He had battery on a police officer.
I'm not going to compare you to other.
Battery on a police officer.
I'm not going to compare you to other cases right now because I can't remember. It's not fair to me. I don't know why I did what I did.
I've been in jail. This case been going on.
Let's move on. I've answered your question. What else is there? Go ahead.
Sitting in jail for 3 years, Mr. Clark.
I understand, but tell me what else. No, you ain't sat in jail for 3 years. This was the.
Yeah, for a few months when I caught that BS charge, but I got a total time before 3 years in jail.
Let's go. What else we need to do?
Set me up for a bond here.
Okay, December 19th at 9 o'clock.
Okay, well, wait a minute. I ain't done yet. I still got some motions I want to file.
Okay, you can file them. Now, have you got copies for the state?
Yeah, I got copies for the state
Okay,
too.
you need to provide Mr., I guess it's Mr. Ferrer.
Oh yeah, what about on my new case? Okay, on my new case, I never had a driver's license, right, in my life. And the fact that I'm charged with a felony is wrong, because driving without a valid driver's license is a misdemeanor, even if you are habitualized.
Hey, you need to file a motion.
Well, I got the motions ready right
We'll
here.
file it.
Okay, I'm about to file it. But my thing is, if it's already on the court's attention that the information that was filed on me was wrong, that's a fundamental error.
That's
It's impossible to
this
charge
is
me with it.
unsworn testimony. I got no idea, but file your motion. And we've got everything. We'll set.
We already been through that because I'm a charge before, on a case before, you already corrected that charge. So why is?
Listen to me. I'm not arguing with you. This is a pretrial. I'll set your motions for December 19th. If you want to file your motions now and get everybody
I'm
ready.
right now. I'm filing. Okay. What about my? Oh yeah. Back to the representation thing that we had.
Okay.
Okay. I have a copy of my transcripts,
Yes, sir.
and you said that I expressly requested counsel. I got a copy of my transcripts to prove that that's not true.
Okay. Well, you on what case?
On my 23 case, I got a copy.
You represent
represent
yourself
me.
on that.
No, but you made me redo it. I had you
What is,
denied all my
what is
motions.
what is your relief? What relief are you asking
My
for?
relief is that I want my motions to be heard that was denied
December
under Booker
19th.
versus State.
Look, we're gonna set the pre-trials for January 18th.
January
What I said, if you-
Listen, Mr. McCoy, you're hearing this over with today. I've listened to everything I'm gonna listen to. We'll set your motions. If you want to file them right now, give the state their copies December 19th at 9 o'clock for the motion. I'm assuming it's a motion to reinstate bond. It may be a motion to
It's a motion for
dismiss.
motion to discharge and a motion for notice.
All right, file them and we'll set it for December
Motion to
19th. We're gonna
dismiss.
set, we're gonna set everything for January 18th for
Let
a
me get my
pre-trial.
motions ready. I ain't ready to be pulled out yet. I gotta get a state.
No, sir, you can hand it to them, but this is, you're hearing over with today.
I can't get them my motions.
Yeah, that's got nothing to do with us.
All right, I gotta get them ready.
You just let Mr. Devontae McCoy sit in the courtroom and get his paperwork ready and let him file his motions and give his copies to the state.
You have a nice day, Mr. Clark.
Huh?
You have a nice day, sir.
You too, Mr. McCoy.
In back-to-back hearings that tested every ounce of judicial patience in that courtroom, two men facing the possibility of spending the rest of their lives in prison made decisions that left everyone in the room shaking their heads. Starting with Jamar Kamari, a man standing before a judge with 2 life sentences on the table, who had just watched his attorney turn down a 25-year plea deal on his behalf, and was now being offered a final chance at 25 years mandatory minimum before the state revoked the offer entirely. His attorney had done everything right. Gone to the jail, sat with him, explained the exposure, given his honest professional advice that taking the deal was in his client's best interest, and Kamari had looked him in the eye and said no. But what unfolded next in that courtroom was something far more complicated than simple stubbornness. Kamari began insisting he didn't understand anything being said, claiming conspiracy between his own attorney and the prosecutor, invoking his Fifth Amendment rights, demanding his attorney be removed, and declaring that the name on the charging documents did not refer to him as a living man. Classic sovereign citizen-style arguments delivered by someone who, as the judge would soon discover, could barely read or write past a 9th grade level. When Kamari demanded the right to represent himself at a murder trial starting the following Monday, the judge patiently walked him through every requirement. Could he pick a jury, understand rules of evidence, cross-examine witnesses, file motions? And Kamari's answer to all of it was some version of, "I'm gonna learn, and I'ma do what I can." The judge, refusing to let a man walk into a life sentence trial representing himself when he admitted he could barely spell, found him not competent to represent himself, kept both attorneys on the case, and told him to be ready for jury selection Monday morning, leaving Kamari furious, his attorneys exhausted, and a 25-year deal that was about to disappear forever sitting on the table untouched. In the second case, Devontae McCoy, a man already representing himself in one of his 3 open cases while being represented by counsel in the other 2, appeared before the same judge, having been held without bond since January after picking up a new charge while already out on bond, and proceeded to spend nearly the entire hearing relitigating decisions that had already been made, asking why someone else had been released last month when he hadn't, arguing that his felony driving charge was legally improper because driving without a license should only be a misdemeanor. Referencing transcripts he claimed proved the judge had previously mischaracterized his request for counsel, and filing a stack of handwritten motions he'd prepared himself from inside a jail cell. The judge, who had clearly been through this particular dance with McCoy many times before, told him plainly that he was treating him exactly like a lawyer, and that when a lawyer repeats themselves and relitigates settled matters, they get a very short leash. Before setting everything for December 19th, watching McCoy scramble to get his paperwork organized inside the courtroom, and sending him off with a, "You have a nice day, sir," that carried the particular exhaustion of a judge who knows this conversation is never truly over. Two men, two life-altering crossroads, two completely different styles of self-destruction, and one judge who had to hold it all together before lunch.
It seems to me, Your Honor, that the lady standing to my right is trying to challenge the foreclosure, and that time period has well passed, and this is not the court to do
Yeah,
that.
that we're in the wrong court.
No, we're not, Your Honor.
Yeah, because I'm not a tenant. I'm a
Okay,
owner.
ma'am. Well, that's just the characterization of landlord and tenant. But it's
There's
for
no
anybody
contract.
that's in premises where they don't have the right to possess them. They can come here. And the right to possess is based upon who has the deed, basically. And in this case, they're saying they got a sheriff's deed because the property was properly, they claim properly foreclosed upon.
No, it was
If
not.
you're challenging the foreclosure, I don't know what you're claiming that's wrong with the foreclosure.
Well, the note was separated from the mortgage, number one, and you can't do that.
Okay.
And Your
That's-
Honor,
That's against the law.
when you purchase a home, there is a promissory note and there's a deed that is provided. Those are two separate and distinct things. We are not discussing that. We are discussing whether or not my client has the legal right to possession of this property, and that there is no defense.
There is a difference.
Well,
The home is in
ma'am, you
probate.
say you filed another case about to quiet this title because you believe something is wrong with
Oh,
it.
yeah, no, I'm not, I believe, I have proof. I have
So where's the other case pending?
that's what I was trying to get down there to file it. I just haven't made it. But I will be there this week for sure.
Because right now, all I have is what they provided to me.
And
I didn't send you a copy of what I had sent them when I tendered the payment and they sent it back.
But ma'am, I don't know what you mean by payment. He says it wasn't a check. What was it?
Okay, it was a negotiable instrument that could have been used as a check, but it was.
Well, what was behind it? What kind of negotiable instrument?
Well, it was connected to the treasury.
Your Honor, may I approach?
The treasury? Like the US treasury?
It was the Michigan treasury, not the big one.
I would ask, is this what you're?
Yeah,
piece of paper?
no, it's part of it.
I'm holding in my hand a document that says this is a non-cash item, not a check on the top. And may I approach, Your Honor, so you can take a look? This is what we're discussing.
Okay. I don't know what this is. It's got some numbers on it.
It's not drawn from a bank. It's not a check.
It was gonna be drawn. from-
Payable through Tracy Moore and done in good faith. That's her address. It says it's paid to HP foreclosure. And then it has
Yeah,
United States Treasury, Pennsylvania
Yeah,
Avenue,
cool.
real property for set off an adjustment. And it's signed by Miss Moore without recourse. This says void where prohibited. Non-cash item per 12 CFR subsection 229.2 U1, 2, and 4. And it says here, this is a non-cash item as defined by that section I just said of CFR and issued according to 12 CFR 229.2 K3 and 4. Non-cash item means an item that would otherwise be a check, except that a passbook, certification, or other document is attached or is accompanied by special instructions as a request for special advice on payment or dishonor, or it has not been pre-printed or post-encoded in magnetic ink with the routing number of the paying bank.
I believe in other words, it's a piece of paper. It's nothing.
A negotiable demand draft by the U.S. Treasury, a demand draft drawn on the state government or unit of general local government that's not payable through a bank. Okay, I mean, you just, I don't know what this is, but you said that no money accompanied this. So, and this was, I don't know when it was dated, June 10th.
Mhm. It was within the time period,
But
but they held it and then.
well, let me ask you
they
this.
sent it back.
Where were they supposed to cash this?
Well, they would have sent everything to the treasury. It was all the original, it was everything. All they had to do was just send it to the treasury.
And the treasury has $153,749.97 that belongs to you, that then they were just gonna pay to them.
Yes,
Okay. I don't see how that could happen.
well, we wouldn't know because they sent it back.
Because my client can't do anything with that.
Well, when I called, why didn't they say that? They held it for 2 weeks.
They don't
And
need to do
then-
anything with that. It's not a payment. If there was a payment, they would have to accept that payment. There was no payment.
So, other than your issues thinking that something's wrong with the foreclosure itself.
Oh, yeah, I had a securitization audit done.
Okay.
And it shows it. And
Well, ma'am,
in
I guess my question is this. If I'm gonna have a trial, which is what the date was originally scheduled for, I just see some real question of fact. I'm not exactly seeing it. I got a sheriff's deed, and I know it's a redemption period of 6 months. You got this, which is, to my knowledge, not any type of cash item. And I don't see how where they would take it to even try to remit or cash it. I mean, it's like I did. I don't know where you got it from, but it says the document has a background in micro printing, and there's an artificial watermark on the reverse side. I have no idea where you got this and how they were supposed to cash it.
just needed to send it in. And I would like to know, how do they have title if I'm living in the home? I thought 9/10 of it was possession.
I don't know what that means. I can tell you that they went through what is known to be a valid process in Michigan, which is a foreclosure by advertisement.
That is so not constitutional. And that was why I had brought up your oath also, to kind of make sure that I got a little help, because you took an oath to uphold the Constitution. And
I'm very fully willing and able and capable of doing that. But where's the constitutional issue here?
Well, this
is a matter of Michigan statute.
No, but it's not a law. Statutes are not laws.
Okay, well then what are they?
What do you mean, what are they?
If they're not laws, what are they're on the book? They're on the books as laws in this state. So I'm not sure if they're not laws to you, what are they?
No, I mean, they're laws in a sense, but not laws by the Constitution. They're not laws made from Congress. Congress makes them.
Well, ma'am, there's federal law and there's state
yes,
law.
Yes, but state comes from the federal.
No, it doesn't. What do you mean it comes from it?
Not,
do you realize you got 50 sovereign states here that can do their own thing,
correct,
separate and aside from what the federal government does? And they do it all the time. All the time. What they can't do is something that is a constitutional violation of their state constitution or the federal constitution. I don't see what this is a violation of a constitution. just to foreclose on property when the bill hasn't been paid.
But it was foreclosed unlawfully from Huntington. They didn't have a right to foreclose. They separated the note. And that's a known fact. They never recorded the note. They recorded the mortgage. And you're not supposed to do that. That's what part of the affidavit said on the man, the gentleman that did the audit for me. That is not lawful.
Your Honor, if that's the case, there was plenty of time to challenge that in the circuit court. This is not the forum for that. The time has lapsed for that to be challenged.
No, it's fraud. It's always a challenge in fraud.
You know, I've got some case law somewhere on the fact that, you know, the time to challenge these kinds of things in the foreclosure would be during the time that you have redemption. It would be at the circuit court. I mean, at this point, the redemption period is over, but if there's something that went wrong with it, the circuit court could rule on it, but you don't even have a case there.
Or I will. I'm working on it.
Well, you know, ordinarily, I mean, this would be the trial date, but I just don't see where the issue of fact is that will require us to actually have a trial in this instance.
What I'm asking, can you give us a trial date, please?
This is the trial date.
Oh, okay, I just misunderstood you.
Yeah, this is the trial date. And of course, I have them call witnesses if I thought it was necessary, but I don't see where it's necessary. I mean, all the documentation he has looks good, and you don't have any documentation that says this is not good, except for your statements that you believe are accurate. And if you wanted to file something, you have plenty of time to file something, Ms. Moore, to challenge this in the proper court. This court just says, was there a proper foreclosure? You know, did they follow? There's just a process, there's procedures, you know. When they file it, they have to give certain notice, do certain things, give a redemption time.
They still didn't do that properly.
Well, what didn't they do?
Well, they were supposed to have served me and they didn't.
Served you with what?
Served me of the first paperwork. They were sticking stuff on.
So you say it was never noticed in any kind of way? It wasn't tacked?
No, I'm not saying never, but I wasn't personally served.
You don't have to be personally served if they can't find you personally. They have alternate means to tack and do things.
They didn't really. But still, this.
Did you want to add something to that?
No, Your Honor, I'm just asking for a judgment to issue.
No,
Okay, well, the court is constrained to have to grant his relief because they don't see the issue of fact here for trial. It appears based upon a review of all the documentation that's been provided that there was a valid foreclosure sale. Redemption period has passed. There was some type of something proffered that doesn't appear to be known legal tender for the, I guess, the redemption amount. And if there is any question about the foreclosure itself or the validity of this tender, I think at this point should have been litigated at the circuit court. So I'll go ahead and give the judgment of possession for the plaintiff.
I object.
Yeah, and you'll have, after I sign this judgment, you'll have 10 days to file an appeal. The writ date will be, if I have the judgment today, it's going to be December 7th. And that's the appeal date.
Thank you,
In back-to-back hearings that tested every ounce of judicial patience in that courtroom, two men facing the possibility of spending the rest of their lives in prison made decisions that left everyone in the room shaking their heads. Starting with Jamar Kamari, a man standing before a judge with 2 life sentences on the table, who had just watched his attorney turn down a 25-year plea deal on his behalf, and was now being offered a final chance at 25 years mandatory minimum before the state revoked the offer entirely. His attorney had done everything right. gone to the jail, sat with him, explained the exposure, given his honest professional advice that taking the deal was in his client's best interest, and Kamari had looked him in the eye and said no. But what unfolded next in that courtroom was something far more complicated than simple stubbornness. Kamari began insisting he didn't understand anything being said, claiming conspiracy between his own attorney and the prosecutor, invoking his Fifth Amendment rights, demanding his attorney be removed, and declaring that the name on the charging documents did not refer to him as a living man. Classic sovereign citizen-style arguments delivered by someone who, as the judge would soon discover, could barely read or write past a 9th grade level. When Kamari demanded the right to represent himself at a murder trial starting the following Monday, the judge patiently walked him through every requirement. Could he pick a jury, understand rules of evidence, cross-examine witnesses, file motions? And Kamari's answer to all of it was some version of, "I'm gonna learn, and I'ma do what I can." The judge, refusing to let a man walk into a life sentence trial representing himself when he admitted he could barely spell, found him not competent to represent himself, kept both attorneys on the case, and told him to be ready for jury selection Monday morning, leaving Kamari furious, his attorneys exhausted, and a 25-year deal that was about to disappear forever sitting on the table untouched. In the second case, Devontae McCoy, a man already representing himself in one of his 3 open cases while being represented by counsel in the other 2, appeared before the same judge, having been held without bond since January after picking up a new charge while already out on bond, and proceeded to spend nearly the entire hearing relitigating decisions that had already been made, asking why someone else had been released last month when he hadn't, arguing that his felony driving charge was legally improper because driving without a license should only be a misdemeanor. Referencing transcripts he claimed proved the judge had previously mischaracterized his request for counsel, and filing a stack of handwritten motions he'd prepared himself from inside a jail cell. The judge, who had clearly been through this particular dance with McCoy many times before, told him plainly that he was treating him exactly like a lawyer, and that when a lawyer repeats themselves and relitigates settled matters, they get a very short leash. Before setting everything for December 19th, watching McCoy scramble to get his paperwork organized inside the courtroom, and sending him off with a, "You have a nice day, sir," that carried the particular exhaustion of a judge who knows this conversation is never truly over. 2 men, 2 life-altering crossroads, 2 completely different styles of self-destruction, and 1 judge who had to hold it all together before lunch.